the Albert family is close, correct?
Yes.
Your son Colin is particularly close to your brother Brian, is he not?
Objection.
I'll let him have that. Do you know?
Yes.
In fact, your son Colin was a football player through high school, was he not?
Yes.
What was his number?
In high school?
Yes.
34, I believe.
And was that for 34 Fairview?
I don't think so.
Can you explain for the jury who or what is Nebercracker?
What is Nebercracker?
Yes,
Like the character?
that's what I'm asking.
It's a character in a cartoon called Monster House.
And would you agree with me that Nebercracker in the movie Monster House was this kind of old curmudgeon who didn't want anybody on his lawn, correct?
The character, yes.
He was the get off my lawn guy, correct?
In the movie, yeah.
What was your nickname and your wife Julie's nickname for John O'Keefe?
Mr. Nebercracker.
All right. And your wife Julie actually had John O'Keefe plugged into his contacts as Nebercracker, correct?
Correct.
In fact, you were there one time when Julie showed Karen Reed, her phone to show how John O'Keefe was plugged in as Nebercracker, correct?
I believe so.
And this whole nickname started because of a conflict that Colin Albert had with John O'Keefe.
Not correct.
John O'Keefe complained to you about things that Colin was doing.
Not correct.
He would tell you that Colin used to throw beer cans or beer bottles in his bushes, correct?
Objection, Your Honor.
That is not correct.
John O'Keefe told you that Colin used to flip him off, correct?
Not correct.
And say F you to him.
Never.
Colin used to cut through his yard.
Nope, that was Dylan.
You knew that John didn't like people cutting through his yard, correct?
No, I don't know that to be true.
Okay.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay. How is everybody? Feeling much better. Thanks for your patience. I don't know how long this is going to be. As long as I can hold out a little bit. I've been struggling with an ear infection, my right ear. So headphones, not super conducive to wearing headphones and doing this kind of work, but we'll see how we get through it. Today we're talking about the Karen Reed trial and what I think is just an absolutely frightening turn of events, and maybe not for the reason everyone is discussing. So what happened this morning is that the trial stopped. Karen Reed and her attorneys were out of the courtroom, ditto the jury, and it became a discussion about Karen Reed's PR lapdog, is what I'd call it, blogger Aiden Kearney. He got a press pass. He's was today for a few minutes, one of 10 journalists in the courtroom. And of course, because he has allegations and indictments against him for witness tampering, witness harassment in this case. The Commonwealth was not too pleased to have at the idea of having Aidan Kearney sitting up there in a very small courtroom where these same witnesses are testifying and having him stare down the witnesses. Now, just to be clear, a judge can kick out anyone in the courtroom that they want. So I have been in the courtroom when a journalist was kicked out for a look, just giving a look that the judge didn't like, that he thought might be prejudicial to the jury. And that was in that was in Nexium Keith Raniere's trial. So what didn't come up, which I think is more concerning, is Aidan Kearney's own words concerning jury nullification, hoping that someone lies and gets on the jury. His admission that they were trying to poison the jury pool before this. So I think that a reasonable argument could have been made, but it wasn't made, that he is a serious threat to Karen Read having a fair trial and to every member of the jury as far as being doxxed, being harassed, being intimidated into acquitting Karen Read. None of that came up. We're going to take a look at how it all went down with Aidan Kearney's lawyer was there. Aidan Kearney, of course, was tweeting, "Oh, my lawyer's just here because of another case that he wanted to interrupt the Karen Read trial and talk to this judge who's overseeing this other case about." When does that happen? Like, excuse me, judge, I know you're in the middle of a really high profile trial, but let me just bend your ear for a moment. I know you have a lot of extra time on your hands in between this really massive media magnet of a trial. I know you have plenty of time to talk to me about this smaller case and this smaller issue right in the middle. I didn't believe that. It seemed he showed up to support his client, Aidan Kearney. His name is Brattle. We can check out. He's also a former prosecutor. We can check out his argument to the court. But I think that this turns the trial in a really very dangerous way as far as fairness. And now Karen Read supporters should want the jury protected, should want a fair trial, should want this to be played out in the courtroom and not the media. But I don't know if they're getting it. Let's take a look at what happened.
Back on the record on the Read matter.
All right, there's sort of a side issue in the Read matter. So the defendant and her lawyers have been excused. Okay, so why don't counsel identify yourselves, please?
Sure. Adam Lally for the Commonwealth, Your Honor.
Okay.
Sarah McLaughlin for the Commonwealth.
All right, good morning.
Good morning.
As they're saying their good mornings, Latin Rican says once it's shown Colin Albert was gone before John and Karen arrived, she's done. Their entire Hollywood movie script goes to the garbage. Yeah. See, what I'm saying is, I'm wondering if any of this matters anymore, what happens in the court. I think that it's such a massive concern, let's say, that the jury can vote confidently guilty without worrying about their own safety. And people vote in their interests. I'm very concerned about this turn of events. I don't know how it's going to go. I don't know if any of the evidence matters anymore. And you can see that the press seems to be just jumping on the free Karen Read bandwagon, either for money or they agree with this kind of ideology that they don't like our police. They think of the Commonwealth as the man, and they think of anyone up against the state as the little person caught up in it. So I don't know. I mean, we're going to get into some of the talking points, some of the things that they're talking about. And I find it bewildering. B. Tim says, Turtle Boy was so mad that his chat and him were doxing the judge while they were live. Turtle Boy was so mad that his chat were doxing the judge while they were live. Yeah, I mean, everybody is, I've never seen a campaign like this, kind of pre-trial, goes through the trial innocence fraud campaign in a criminal trial before. And if this works, we're going to see this again and again and again. And they'll repeat it. And Karen Reed does not have, so far, we haven't seen the defense's case yet. But the cross-examinations, if you're paying attention to the opening, were super weak. Nebbercracker? That's their defense, Nebbercracker? All right, let's watch.
Your Honor, Timothy Bradle
watch
on behalf
that.
of non-party Aidan Kearney, who for the record is present in the courtroom.
Hey, does Mr. Kearney want to sit with you?
I think he's okay right there,
Okay.
if that's all right, Your Honor.
All right. So, Commonwealth, so I do want to say a question before we begin. Commonwealth, in your motion to exclude an individual charged with witness intimidation in connection with this case from the courtroom during the testimony of certain witnesses, before we begin, are you advancing the concerns of the DA's office or the concerns of the witnesses themselves, or both?
Both, Your Honor.
Okay,
Judge,
so,
if I may, I'm sorry to jump in, but just if I may, I do have what I think is a pretty substantial procedural objection.
Okay.
Maybe I'd ask that you sort of just make a quick bifurcation of the issues here, and we can address the procedural issue before we get into the substance of the motion.
sure, I'll hear you.
We could. Thank you very much, Your Honor. Your Honor, so the record is clear, because we may need an appellate record in this case.
Okay.
But I was here in the Norfolk Superior Court today, completely unrelated to Mr. Kearney, my client, as you know, in the other matters. And I was here today on the matter of Commonwealth versus Tylee Curry for a motion to suppress. And that's-
Which is a case that I am in the middle of
Right.
that motion to suppress with you.
Exactly. And I actually figured that we wouldn't do the motion and get a date. But I was fully focused on that matter and had no notice whatsoever that the Commonwealth was in the Reed matter, was seeking to exclude my client as a journalist from this courtroom. The first thing is that, and I know the court has a job to do in terms of ruling on this motion, and that's fine. And I ask that the ruling be that it be denied on procedural grounds. The procedural grounds are, Judge, that there's been no service of process whatsoever on a case where the government is seeking to essentially trample all over my client's First Amendment rights as a journalist. On 15 minutes notice. You know, I know you gave me the thing 15 or 20 minutes ago.
And it's more than a half an hour, but I understand.
All right, well, you get the point. So, you know, this is not something that I can process and absorb and make any sort of cogent arguments on the merits of the motion on that time period. I'm sure that the court respects that. I'm trying to address it as best I can, but I think that the procedural issues here should control. And here's the procedural situation, Your Honor, that the government filed this 6-page motion. There's a footnote 2 that refers to them serving this motion on May 8th to the Associated Press. Why they couldn't just pull up my email and serve me is an open question that I'd like an answer to in open court. So they can serve the AP 2 days ago, but they can wait and not even.
So is he talking about the Associated Press? So for those that don't know, Nevercracker is a cartoon character, and John O'Keefe was jokingly called Nevercracker by Chris Albert, but it had nothing to do with Colin Albert, and the whole story spun by Turtle Boy, Aiden Turtle Boy Kearney, that Colin Albert had thrown beer cans on his lawn, meaning John O'Keefe's lawn, and that's why everyone in the Albert home attacked John O'Keefe that night, even though there's no proof that John O'Keefe even made it in the house. In fact, there's zero proof. And then there's zero proof that he was put out on the side of the road, unless they're saying they did it by hot air balloon or some kind of flying device, because there's no footprints in the snow at all, no trail of anything. And you can see from John O'Keefe's phone that he never moved. It never is tracking, never moves from that spot. So Latin Rican says the potential defamation case. So you're talking about the civil courts after this criminal trial is done. And that's where this may end up, mostly in our civil courts against Turtle Boy by those families, are going to be massive. He might never recover and might call someone else daddy. Yeah, maybe. Be interesting to see what lawyer wants to take on. These are really, Karen Reed has super powerful lawyers. Be interesting to see who would want to represent any of the Alberts or even the O'Keefe family as far as a wrongful death suit. I mean, we may be going into OJ territory. So what I'm saying is communicating is that these campaigns are very powerful. And I'm losing faith in this trial being kind of, what do we call it? In a bubble away from this campaign. I feel like the campaign has really come into the courtroom. And when that happens, we tend to see crazy verdicts, totally unjust, strange verdicts that don't have anything to do with the trial we just witnessed. So Kathy Chapin, thanks for the super sticker. Appreciate it. Nice to see you here. So this is Mr. Bradle, who is Aiden Turtle Boy Kearney's lawyer, arguing that Aiden Kearney should be in the courtroom as a member of the press all the time through the entire trial. It's his First Amendment right. So, of course, he has a First Amendment right to write about this trial. We have open courts in our country, but once you insert yourself and start intimidating witnesses and start talking about the jury, I would argue that you are a threat to Karen Reed's right to a fair trial. You should want that. And I would really like the Free Karen readers to put on their thinking caps and think, why does Karen Reed want to harass witnesses in this case? Now, there's been a real connection made. I think multiple, I'm thinking tens of phone calls, 44, 64. That's my memory. Take that with a grain of salt. From Karen Reed's lawyer to Aiden Kearney. There's obviously been, now they've said we have nothing to do with him, but it's clear that they were leaking information to him to spark off this campaign in an effort so this would never go to trial. That was always the aim. And if you look at David Yannetti's record, he has a really good record of getting cases dismissed before they ever go to trial. What's Alan Jackson really good at? Seems to be his specialty is destroying witnesses in Cross.
Serve me with the motion when I get here to court today on a completely unrelated matter, I might add. So there's some funny business going on.
I mean, there's some funny business going on. I think he protests a little too much about how he's here for an unrelated matter. How long is he going to talk about this? Unrelated. I'm really here for an unrelated matter. I'm really not here just to protect my client's First Amendment right, because I really needed to show up at this motion to dismiss other case. And when was that other case supposed to happen? This went all day today. So when was this other case? When did he think he was going to be heard for this other case? It seems a little sus, but I don't have all the facts here.
On here. And, there's been nothing but funny business from where I sit from the Commonwealth on Mr. Kearney's matters. And here we go again. So I don't appreciate that from counsel, from the Norfolk County DA's office, number one. Number two, Your Honor, Mr. Kearney has covered this case and written about 350 news articles on this case. He has developed evidentiary scoops on this case that have added to the quantum of evidence.
He's created stories, right? He's taken a grain of truth that they maybe say did call John O'Keefe never cracker, but created an entirely fictitious story around it. My client has used his imagination and created basically the equivalent of fan fiction on this case. And it's been a great asset to the public, hasn't it? Hasn't it been a great asset, everybody?
Evidence in the matter. He's never caused a problem. He wishes to be.
He's never caused a problem except for those times that he's harassed witnesses and bragged on his channel that he hopes that his fans will get a spot on the jury and just don't get caught lying. Anybody remember that? He's never he didn't do nothing, guys. He didn't do nothing. My client is totally innocent. Didn't do nothing, guys. Oh, this is why people don't like lawyers. This kind of stuff. Latin Rican, once we potentially see no dog DNA found, the case is over and she should hope for a lighter sentence. It will be a heavy sentence. Be curious to know. I'm not so sure she's going to get convicted the way this is going. This is a major turn. This is a major thumb on the scale from the defense. Because Aidan Kearney's been in the courtroom. He's seen the juries. And who knows what's next? He seems to stop at nothing. Common sense goes out the window. He's not afraid of more charges being thrown at him. And he was bragging right after this that he's gotten so many more followers on social media. And he's even more famous. So he's willing to really break the law. I'd say he has an antisocial personality. I think that's pretty obvious to everybody. No. And the judge, maybe she's afraid of getting any more harassment than she already has, seems to be capitulating to the mob here.
In the galley of journalists, like everyone else, and cover the case. There's never been a problem whatsoever. This is more personalized retaliation from the Norfolk County DA's office against Mr. Kearney.
So that's a little deny, attack, reverse victim offender right there. So we know that Aiden Kearney has retaliated against anyone, doxing them, going to their business, harassing their business, leaving bad reviews for their business, basically trying to destroy their life, starting a campaign of hate against anybody who was set to and did testify against Karen Reed. We still have some more people that are up to go who have been harassed by Aidan Kearney. He all set a harassment campaign against them. Now they're accusing the Commonwealth of doing what they themselves have done.
Another point, Your Honor, is that this matter, as far as the Commonwealth is concerned, is res judicata times 2. Judge Krupp in this very court addressed this exact issue about Mr. Kearney covering this matter, being in the courtroom with witnesses that had a stay-away order. All the same people that the government is trying to have another bite at the apple with here. All these people, this was adjudicated fully with the Special Assistant DA before Judge Krupp, and Judge Krupp ruled against the Commonwealth. Judge Krupp said that Mr. Kearney was able to be in the courthouse covering this case regardless of any of these witnesses in the stay-away order. The stay-away order was exempted from Mr. Kearney's presence in the courtroom, rather, was accepted from the stay-away order.
Okay.
So this is done. This has been adjudicated. It's been adjudicated again, Your Honor, by Judge Pomerol across the street in the district court. One of these people associated with.
This is ridiculous. It's ridiculous to say it's already been adjudicated and forget about it and look the other way. So damage has already been done. He's already seen the jury. So if he never comes back, he's gotten what he's wanted. He's gotten his fame. He's gotten a real look at the jury. Who knows if he's taken photographs or video. Let's hope not. Scary. There's no way the jury is going to look past all of the accusations disproven. That's including her taillight broken before it was taken. Great point, Latin Rican. And look at where the press went with that. So a couple days back, Lally, the prosecutor for the Commonwealth, ended with a photograph of Karen Reed's broken taillight at, what was it, 8:28, around there in the morning? And it was like a blackout in the press. No one talked about it. It was so odd. It was like it never happened. Devastating for Karen Reed. So hey, Manny, this is Turtle Boy is brave. I wish him well. Free Karen Reed. Good. All right.
Mr. Kearney's detractors, Ms. Gattani has taken up with the Commonwealth and sought charges and sought a restraining order against my client. And Judge Pomerol recently, as recently, I think it was a couple of weeks ago, we were across the street, Your Honor, seeking to vacate the order under the doctrine of unclean hands because this plaintiff keeps trying to contact my client while under a restraining order. Putting that aside, the ruling in that matter, Judge, was another ruling in support of Mr. Kearney's First Amendment rights. It was another ruling that said Mr. Kearney was not subject to the restraining order in any court of the Commonwealth. And the reason we brought that motion, Your Honor, was because these same witnesses that the government here is, again, trying to advocate for their own personal issues, those same witnesses somehow took up with this plaintiff across the street, Ms. Gattani, brought her to court here in prior Reed proceedings to kick out Mr. Kearney, because at the time she had an operative order against him. And Mr. Kearney, to his credit, got up and left and got out of here. And that situation was what we addressed across the street with Judge Pomerol. He agreed with us and said, you can go to court, you can cover this case. So number two, litigation number two, this has been established. Mr. Kearney followed all proper channels. We worked with the SJC media office. He has a press pass. He's doing everything in accordance with all of the rules and regulations that are in place. He's been harassed, and we have it on video, by other so-called journalists on this case at the steps of the courthouse. And he just wants to be here. He
Right. I think they're talking about Grant there. The so-called journalists, they got into a little bit of a tiff. So that'll be interesting to see if Grant's press pass is or going to be revoked.
He doesn't want to be an issue in this case. He wants to sit here and cover the case. He's done his job. He wants to watch the trial unfold. And he has an absolute fundamental First Amendment right to do so within the confines of this courtroom and within the confines of time, place, and manner restrictions. He's followed everything, and he's here. We've gone through all of these hurdles, Your Honor, and Mr. Kearney triumphed, as he should, because it's the First Amendment that needs to triumph here, not any particular person. And that's what he's doing. And there's absolutely no reason for the government to sneak behind my back to interfere with his First Amendment rights. It's out.
Sneak behind his back. No one's sneaking. They're trying to give Karen Reed a fair trial. You should want that, Mr. Brattle. Latin Rican, I think there's possible friction going on behind the scenes between Turtle Boy, Karen, and her team. There's more than meets the eye, in my opinion. That would be interesting to know. Who could know what's going on behind closed doors? She seemed pretty angry at her team a couple days ago. It hasn't been going well for her, clearly inside the courtroom. It's a great strategy for her. We're all talking about it. But what it does, like I said again, is it brings in this outside campaign into the courtroom. And the jurors, I hope, won't be intimidated, won't be doxxed, won't be harassed. But we can't know for sure. And if they were, would they feel comfortable speaking out?
Outrageous, and on procedural grounds, I ask you to deny the motion for all of those reasons. And if the court has some hesitancy to do so with respect to these procedural issues, I ask that you set a date give me 7 days or so that I can properly respond to this motion on the merits of whatever's in these 6 pages of the motion that I haven't been able to look at. So thank you for hearing me, Your Honor.
All right, sure. And you wanted a response to your question from Mr. Lally on why you were not served, but the Associated Press was served.
That's correct.
So if you talk about that in the procedural part of this, Mr. Lally?
Yes, Your Honor. Simply put, Mr. Bradle, neither Mr. Bradle nor Mr. Kearney are parties to the case. I can't presume that Mr. Bradle's representation on one criminal case is going to extend to a motion of which he would be at best a third party on a separate criminal case. We are required under the SJC rules to serve it upon the Associated Press, which we did.
Okay. So I think that's your record now, Mr. Bradle?
Thank you.
Okay, on the procedural issue, okay? We have a jury out. I do want to address the merits of this as best we can. And Mr. Bradle, at the end of this hearing, whatever I end up doing, if you want to come back and readdress it when there's more time, depending on how I rule, I'll give you the opportunity to do so. But I have to get this trial moving at this point one way or the other. So I'm going to hear the Commonwealth on their motion. Then I'll hear you, Mr. Bradle, to the extent that you can respond, okay? All right. Mr. Lally, I'll hear you on your motion.
Your Honor, very shortly, very simply put, this is an instance in which the Commonwealth is not asking that Mr. Kearney not be allowed to cover the case or that he not be allowed to watch the trial. What we're requesting is a partial closure.
Partial closure. closure. They should have said no yet. Once you start harassing witnesses in a case, forget it. Like I said, I've seen journalists thrown out for a look on their face. So judge controls the courtroom. This is a major, major fail by Judge Kearney in this case. And I wouldn't be surprised if we get a very wacky verdict from this. It just seems like chaos has come in. The outside has come in to the courtroom, which shouldn't happen in an ideal world. Riziva says the stunt done by Turtle Boy and Karen Reed's defense team, I believe, was by design to send a message to the jury, even though they weren't present. Hey, Manny says, free Karen Reed. Okay, this is sarcastic, you guys. She should reach out to Peter Jackson and Johnny Depp, who worked for the West Memphis 3 for funds. So both Peter Jackson and the West Memphis 3 put a lot of money. $40 million was spent in getting the West Memphis 3 out. Love you, Roberta Glass. Great stuff. Thanks, Manny. Yeah, so go back to my West Memphis 3 just so they could plead guilty via Alford and give up all their rights to ever sue the state. And now they're trying to sue the state essentially for their quote unquote wrongful conviction through a lot of nonsense DNA testing. It never was a DNA case. And they still haven't released the DNA results for those in the back. West Memphis 3 still has not released the DNA results from 2011. Yet somehow that's their own defense team. Somehow they want more. They want more DNA testing. So I say release the 2011 results first. Then you can ask for your DNA testing, your ridiculous DNA testing.
Of one individual. And the legal standard for that is essentially a substantial reason. Substantial reason, Your Honor, being that Mr. Kearney has been indicted and has open cases for intimidating witnesses, specifically witnesses in this case. He has confirmed statements indicating publicly that his actions that he's taken in regard to those indictments were to prevent the case from ever going to trial and to intimidate those witnesses. Those witnesses will be called to testify in this case, and what the Commonwealth is simply requesting is that he be.
And yeah, so he just hints at it. Here, Lally just hints at it. Aidan Kearney's statements about the jury, about nullifying the jury, about poisoning the jury pool. So it's not just about the witnesses, it's about protecting the jury. And that's where I think we had a failure. Maybe I don't know how much. I would hope you could argue that here. I don't know. Let me know. If you're a lawyer in the state of Massachusetts, let me know if that can be argued here. It should have been argued here, I think. Latin Rican on News Nation. Oh, I have this Turtle Boy. Oh, not this one, though. Turtle Boy said a major gaffe. He said the FBI knows John O'Keefe was not killed inside the house. Then, right after, he changed and said they know he was killed inside. Is this mind games against her? Interesting. Yeah, let's hear the Free Karen Reed story, the defense story, besides poking holes. So there's an interesting meme made. Hold on one second. Let me pull it up for you guys. Look at it really quickly. About Petty Yannetti, Karen Reed's lawyer, David Yannetti, and some of his greater points. So this was his cross. Water is a clear liquid. Are you telling the jury that it's a mere coincidence that it's talking about Colin Albert's jersey and Fairview are both 34? You had potato skins and you want the jury to believe you did not brush your teeth at 12:20 a.m. Clothes absorb moisture, don't they? You use a hot oven. Just exactly who is Nebercracker, Mr. Albert? So those are his great cross. But tell me, Free Karen Reed people, Give me one consistent story with evidence that supports it that anyone but Karen Reed is responsible for what happened to John O'Keefe. They can't tell a consistent story. And then they're going to talk about how terrible, and we're going to get to it, that was on News Nation, how terrible the investigation was. But tell me how those red Solo cups make any difference at all in the results on whose blood that was in the snow. I think everybody concedes that it was John O'Keefe's blood, no? How would putting those pieces of evidence in something else make a difference? How would making a tent over the area make a difference? How would not using a leaf blower make a difference as far as what they found concerning her taillight pieces in the snow? Where's the controversy?
Excluded physically from the courtroom, not excluded from watching the trial, not excluded from covering the trial, but excluded physically from the courtroom while those witnesses are testifying from the stand.
And the witnesses you told me have expressed concern. What do you say about that?
Yes, Your Honor. The witnesses have expressed concern. The Commonwealth is concerned as to his presence affecting their testimony or their ability to recall. And for all of those reasons, the Commonwealth would submit the administration of justice and the witnesses being able to testify, as well as the witnesses' own concerns are more than meet the test of the substantial reason for Mr. Kearney's exclusion during the course of their testimony.
Okay. Mr. Bradel?
Your Honor, the witness's concern has no legal materiality under the law. So the answer that I have is, so what? The witness's concern, where does that fit into the law here, Your Honor? This matter's been adjudicated twice. Mr. Kearney has...
Yeah, where does it fit into the laws that they deserve to testify without fearing retribution? That's where it fits in, Mr. Bradel. This is getting mad. This is like madness. I feel like I'm watching. They want to make this a kangaroo court. Sunny day. Roberta, that was my meme. Oh, good. I couldn't exactly, sorry, Sonny. I couldn't exactly track down who it was. Making them is my stress release. Thank you, because it was an awesome meme. I mean, that's what they have. These are the kind of crosses that they're engaging in. Absolutely doesn't matter. Not important. Total distraction technique, and it's all working. The press is picking up on every single defense distraction and running with it. And the major evidence, like the fact that Karen Reed's taillight was broken on film at 8 in the morning, 8 whatever, 26, 28, around there. The idea, given that there wasn't time to make a conspiracy, it wasn't done in the terrible police's clutches, wasn't planted, it absolutely throws out the idea that any of this could be planted by the police. That talking point, not important. Don't talk about it. It's not sexy. Forget it.
The right to speak on the case. He's gone through all the proper channels to be here. He is not in any way wants to or is trying to make any issue of his presence here. And he's just trying to cover the case as best he can. And this is just a personal vendetta that's been carried out by the Norfolk County DA's office against Mr. Kearney. And this is where the court needs to hold the line on the First Amendment. This witness intimidation statute, Your Honor, is an absolute abomination. It is going to be struck down. It's just a matter of time. And this is just a continuation of everything, the special...
Oh, wait. So he wants the statute that protects witnesses to be struck down? It's an abomination against the First Amendment, and it will be struck down because now he's Bradel Damas and he can predict the future. That's the way it's going to go, Your Honor. I can see into the future. I'm Bradel Damas. It's going to be struck down. So just let my client just sit in here, do what he wants. Let this psychopath have total control over the courtroom. It's not enough that he's made a total joke out of the facts of this case, pumped out disinformation nonstop. Karen Reed's defense team, should she have had a real defense and any kind of real basis for her claim of innocence, would be horrified at having witnesses intimidated here. She would want a fair trial. So, this should really, really, really make your eyebrow go up. No? That she's all for attacking the witnesses, the victim's family, all for attacking the witnesses in this case. This doesn't seem a little odd to anyone. And I'm listening to the talking heads on this case. And let me talk about LawTube. One LawTuber is worse than the next. Why aren't they practicing law? You have to ask themselves, ask yourself, why are they on YouTube? Why aren't they in court practicing law? They're hopping on the Free Karen Reed campaign for clicks and views and bringing up all these talking points, adding major drama. This is the worst police investigation I've ever seen. Really? When they're like a civil lawyer? They don't even do criminal law? Seriously? Seriously, guys? So I'm seeing one talking head after the other bring up completely ridiculous talking points from the defense. And I think we're all forgetting what a trial is. This is not entertainment. This is not an episode of Law and Order. This is an actual trial. They're more like a novel than a TikTok video. Requires a little bit more patience. So all this stuff about Lally being boring, he's not there to entertain. He's there to inform the jury of the facts of the case. Sometimes it's helpful to have a really flashy, dramatic presentation. But that's not his style here, and we got to respect that.
Special counsel's been doing to Mr. Kearney, and now the office itself is doing it. There's no reason for this motion to be allowed, Your Honor. There's no discomfort exception to the First Amendment, Your Honor. There's been absolutely nothing advanced, especially on an emergency basis, which is, I assume, why this is being done with no notice. There's been no establishment of any emergency. There's been no conduct whatsoever on the part of Mr. Kearney to justify this motion. And I did happen to see some reference to.
So there's some admissions in the negative. There's been no conduct by Kearney, meaning he's just being picked on because he didn't do nothing. Guys, he didn't do nothing. He's just being picked on by the poor Commonwealth. He's really the victim, not the people he's terrorizing, not the witnesses he's harassing. Again, Kearney's the victim. This is, again, the reason why people don't like lawyers. Love when I interviewed John Luanne, the king of the cold cases. Anyone watching the Jinx Part 2? It's freaking awesome. Loving it. Lots of John Luanne. I've done 4 episodes with him. He said, if I wanted to say things I didn't mean, he's a prosecutor. So he said, if I wanted to say things I don't mean, I'd become a defense attorney. That's what I think of when I'm watching this kind of stuff. He did nothing wrong, guys. Nothing wrong. Everything's okay. Hey, Manny, the Alleged trampled his First Amendment protected alleged rights for witness intimidation. Outlaw dog bites. We found the DNA. Yeah, they'll never find the DNA. No dog DNA here, but they're still running with this. No dog hairs. I think I'm still leaving cat hair from promoting cats all over New York City. But never mind. Chloe was a magical attack dog that left no hairs, no dog DNA, right, when she attacked. Give me a break.
The Chestnut trial about published is something to the effect of doxing a seated juror. That is false. Mr. Kearney wrote a story on a juror after the jury was discharged.
Right. He went out and doxed a jury because he didn't like the way he voted and made his life miserable and bragged about it. So let me get through. This is so slow. We're almost at the end here, guys. It's going so slow, isn't it?
There's absolutely no prohibition or problem or issue with that. And it is absolutely protected conduct by the First Amendment. And it is not in any way a grounds for this court or the Commonwealth to assert any wrongdoing.
Okay, so spoiler alert, I'm going to get out of this because I can't stand to watch any more of this. But what happened was the judge agreed that Kearney should be out of the courtroom on any of the testimony of the witnesses that he is alleged to have harassed. So Latin Rican says broken taillight before it was taken will work against her. A pink prison suit with inmate number 227 or 227, meaning that's the false information they put out that Jen McCabe did a search at that time when we all know that she really did the search at 6:23, 6:24, and 2:27 is when the browser was opened. Thanks, Latin Rican. But I wanted to show you this. This is kind of interesting to me that there's been a tradition of guilty people creating chaos in the courtroom going back at least to the late 60s, early 70s. And I just wanted to play a little bit of an interview I did about the barrel of a gun, which is about Mummy Abu Jamal, Officer Faulkner's killer. And this is about his trial. And this is the filmmaker, Tigra Hill, talking about how certain defendants would disrupt the courtroom and the real aim of it. How they made the courtroom so they could argue kangaroo court. Let's take a listen. Say, I think his lawyer even says in your film, he didn't have a fair trial. Why was Mumia ejected 13 times out of his own trial?
I wish I could have gone more into this to the film. Again, there's context to that. In the 70s, going back to the Chicago 7, there was among revolutionaries and that were brought up in court, there was a strategy. You disrupt the courtroom, you continue to yell and scream, and you try to take away the focus away from the evidence onto you and to the system. And many defendants were doing this. Mm-hmm. Bobby Seale in the Chicago 7, because he actually had some legitimate reasons, even though Bobby Seale has his issues too. And I talked to Bobby Seale, who was the co-founder of the Panthers with Huey Newton.
Yep.
So you had a series of courtroom disruptions that were going on. It happened in the Manson trial. It happened.
There's an interesting article written by the prosecutor, or quoting the prosecutor, talking about Bobby Seale really choreographing that with his defense team so that he would be gagged and tied up because he was so disruptive. So you hear Mumia got ejected. Did everybody hear for those in the back? The idea is to create chaos, take the focus off the evidence and put it on the system, right? And the person's unfair trial. So is that what's happening here? certainly we're all talking about, right? We're all talking about who's in the courtroom and who's talking about the testimony that happened today. Again, we're just setting it up. And of course, free Karen readers are all saying it's great because they're saying that they all got along. And we're not going to hear, and what's very beneficial to Karen Read is that John O'Keefe's nieces and nephews, who he took on as his own children after the passing of his sister and his brother-in-law, they're going to testify that and I know this from the court filings by the Commonwealth, that they're going to testify that they were fighting all the time, that John O'Keefe wanted Karen Read out of his home, that left and stayed with a friend and left her in his home. That's how badly he wanted her out the day before. They fought on vacation, that they would fight about little things that other couples don't fight about. So in public, yes. How many couples fight in public all the time, especially at a bar on a Friday night? It's very human to put the best foot forward. So I wanted to look at News Nation and how they covered the past couple days of testimony, all very bad for Karen Read. And look at what they're leading with. Again, it seems like in this case, it's the cops who I think did a pretty decent job. All things considered, that they were working within the nor'easter. It's just a little flurries, guys. Just a little flurries. And procedure instead of the real evidence against Karen Read. Let's take a look. Here's Ashley Banfield's show.
Kennedy, she's a senior reporter at the New York Post and has been covering this case very closely. People probably, Dana, don't understand what that humor was about, but he used sort of a dirty word to suggest, well, I'm not a baby. I'll go out in a blizzard if that's what you're accusing me of. It wasn't that he was laughing at murder. I want to make sure everybody realizes this is a very serious case. But this business of the evidence collection, what the heck happened in the courtroom when they started to suggest that blood evidence was collected in party cups and put into used shopping bags that were left open and transported back to the cop shop?
Well, this, as you pointed out when you started talking about this has the air of, the Three Stooges or the Keystone Cops doing a police investigation. I mean, we've been at this. There have been 22 witnesses for the prosecution so far, Ashley, and they seem...
So tell me how that would make any difference if they put them in something else. And even this guest is going to say it would be in a paper bag anyway. Whether it's a Stop and Shop, whether it had Canton PD or state police on it or whatever, it would still be in a paper bag. So what are we talking about here? Were we expecting to find anyone else's fluids except John O'Keefe here? Is anyone saying that it got lost because of these cups? That all this great evidence of a conspiracy got lost because of the cups? If it were placed in something else, there would be tons of evidence of other people. Is that what they're saying? Because that's bananas.
To be more like witnesses for the defense. They've only really been good for the defense. Nothing here makes any sense. Putting blood in Solo cups in a Stop and Shop bag, blowing.
They've only been good for the defense? Really? So we have all the first responders saying Karen Read said, I did this, I hit him. We have about 1 million witnesses now. Not 1 million, but quite a few witnesses who all heard Karen Read say different variations of I hit him, I hit him, I hit him. This is my fault. Is he alive? We haven't even gotten to Carrie Roberts and Jen McCabe. She called them saying, oh, Carrie Roberts, I think he got hit by a snowplow. How did she know that? We haven't heard from the snowplow driver. Said he saw a car that looked awful like Karen Read's right at the spot where O'Keefe was found. 4 a.m, meaning did Karen Reed drive back to the scene at the time when she said she was driving within a 2-mile radius, find John O'Keefe, discover he had passed on, went and collected her friend's Carrie Roberts. That's when she called Carrie Roberts and said, I think he's dead. He got hit by a snowplow on the phone. Collected Carrie Roberts and Jen McCabe to discover John O'Keefe. And there she could put on her big theatrics and her big hysteria show, which I think was for effect. She certainly didn't want to go to the jail. It's very convenient that she went to a hospital where she couldn't be questioned.
The evidence area away with the leaf blower. Actually, this sounds crazy, but it's almost as if they're not even trying to put forth a good prosecution. They're just almost doing this as if it's okay if Karen Reed is acquitted, because that actually could save the cops that the defense thinks are guilty. You following me here? Because if she doesn't get convicted, really, that's a conspiracy theory within a conspiracy theory. At this point, given how this is playing out, you can't blame me for thinking that.
It's super backwards, but I get it.
So she's saying if she gets acquitted, there will be no civil suit against the cops? Oh, you're so wrong. Nothing stops these lawyers from suing for false arrest, wrongful arrest. They're like pigeons. They always come back for more. Latin Rican. The last thing I will say is this. I am a huge fan of your show because you don't let any of her supporters BS you at all. Free Karen Reed is really F Karen Reed. Okay, thank you, Latin Rican, for the compliment. That's what I'm thinking this is. This is a giant disinformation campaign. And shame on Dana Kennedy for failing to see the forest through the trees. I mean, show me how any of this made a difference, and show me what's a better way to investigate during a nor'easter, something that you think is an accident at the time. No one thought that this was a second-degree murder case.
And weirdly today, it seemed like there was a lot of give and take. I mean, here we were looking at leaf blowers and solo cups with evidence, but at the same time, there was some, I think, strong evidence. Prosecutors had texts and voicemails, apparently, that showed that their relationship was on the rocks. And I think that John's niece was in court saying that they fought a whole bunch, that he had tried to end the relationship.
Well, John's niece, she hasn't been in court yet. It's been in filings, but we won't see that, nor will we hear it, and nor can the press report on it. So that's positive for Karen Reed. That's a filing that came out from the judge, that they can't be on film, which is very normal for minors not to be filmed. But usually we hear their testimony, meaning while they're testifying, we see, like, say, the ceiling fan, or it'll focus on Karen Reed instead of the witness or the lawyer asking questions. But in this case, there's going to be an absolute media blackout on John O'Keefe's niece and nephew, which are really like his son and daughter. Really raised them as his own. So that's positive for Karen Reed, in that everyone's going to think that they had a great relationship. They were in the home the most over anyone, and their testimony, both of them, is that they were not in good shape. It was really, the relationship had really run its course.
Repeatedly. How strong was all of that, though, given all the other stuff that we've been seeing that seems to, sway in Karen Reed's favor?
Yeah, we've obviously known about the texts and the emails and the calls, before and after that evening, or that early morning hour, I should say. I don't think that has as much sway, considering how many witnesses, including people that were at those two bars in Canton the night this all happened, all said they seemed very lovey-dovey. There was no bickering. I mean, you definitely can have a tumultuous relationship. That doesn't necessarily mean it's going to end in murder.
No, and I think most people watching, would say that, except for if a lawyer is suggesting that, and you're on a jury panel, and it's made out to be a bigger narrative than perhaps it is. But fascinating. I'm going to have you back because the case isn't over yet and it's getting close. So thank you, Dana Kennedy. Appreciate it as always.
Right. And last time I was on, I was playing Jesse Weber on News Nation again, talking about how he came into this case thinking it was a slam dunk, and now there's so much evidence. He's been blown over by Nebercracker, apparently, and a bunch of nonsense. They just want to, I don't know. I don't know what their motivation is. Dislike of the police. Are they in touch with the Karen Reed defense team? Have they been promised scoops? Who knows? Who knows what's going on here? Do they just want more clicks and views? Tuesday Gazette says it's not a police corruption story. It's a media corruption story. Yeah. We're watching an innocence fraud campaign in real time. And I'm really afraid it's going to be successful. And then all the free Karen Reed people are going to go, see, I told you. After we made it a total kangaroo court. Made the jurors feel totally unsafe. And like they would be possibly doxxed and gone after if they voted wrong, meaning against Karen Reed. I already think that they're already too close. 200 feet is not far enough away from the courthouse. Apparently, Vinnie Politan was saying, no, it wasn't Vinnie Politan, excuse me. It was Ted Daniels saying that you can hear the cheering as they come into the courtroom from the free Karen Reed people. Scary, right? It's not the way our justice system is supposed to be run.
And now I want to bring in Phil Waters. I love Phil as well because he is a retired homicide detective in Houston who's investigated more than 400 homicide cases. So I am curious to get your take about the Solo cups and the used grocery bag and the failure to close it, leave it open, carry it back to the station open. What do you make of that?
Well, good evening, Ashley. This is quite a story here you've got me on. I tell you what, I look at all of these cases objectively, and I will tell you, in this particular case, I've watched some of the testimony, and I have kind of followed how this thing is starting to play out. And you got to go back to the beginning on this kind of stuff. So Lieutenant Lank, who was the detective at the time with Canton PD, that makes that scene, and he calls the state police, and they are the ones that are supposed to investigate an unattended death, and they say, we're not making the scene. We're not going to process the scene. And evidently that department is so small that they do not have the capability or the resources to process a scene properly. So given that, he thinks outside of what he's not able to do and comes up with a way to gather some evidence, to recover some evidence. And so he goes to the neighbor apparently and gets these red Solo cups. Now, I think that
My understanding is that neighbor was a police officer, and he doesn't have the resources to process a scene correctly, or is he in the middle of a nor'easter and they don't know how they're going to preserve the evidence given the incredibly hostile weather conditions?
that's pretty inventive. I mean, I would never be in a situation like that, but that was pretty quick thinking on his part to retrieve some blood evidence out of snow that is going to melt. So he puts it in the cups. Now, the only problem I see with the solo cups is that he didn't put covers on them. And were they used or were they fresh out of the package? So that would be my only question there. Now,
Right. Are we trying to see if anybody else's? Are we thinking that this is anyone else, belongs to anyone else besides John O'Keefe? So he's saying that it could contaminate the DNA. Everything came back belonging to John O'Keefe, is my understanding. But we also have John O'Keefe's glass in the bumper of Karen Reed's car. And I've heard that his hair is on the bumper of her car. Microscopic pieces of taillight in John O'Keefe's shirt. It was such a terrible investigation. All of that was preserved.
in regards to putting in the paper bag, even if they'd have had the proper plastic containers to recover that stuff, that evidence is going to be put in a paper bag. It doesn't matter if it's got a grocery store in the front of it or the Canton PD in front of it. So that part of it, not a big deal. Now, the fact that he didn't seal that bag up, that's a problem in terms of gathering evidence. So I would agree with you there. But in terms of gathering the evidence with the resources that he had, I think there's some quick thinking on his part.
Well, you make a really good case because, look, not every murder has, perfect evidence. You get what you can get when you can get it. And as far as the ingenuity goes about blood evidence in the snow that's going to melt, I do get it as well. But that also doesn't mean that in court it needs to be accepted. It doesn't mean it's great. It's okay, especially since that grocery bag was used, right? And the solo cups, like you said, we don't know the chain of custody on those. We don't know if they'd actually, but they weren't cups from inside the party house. And that's important because inside the party house, there are all sorts of allegations by the defense that the real killers beat him up and threw him out in the snow and are trying to frame Karen Reed. Do you think, listen, Phil, I get it. It sounds crazy when anybody tries to suggest that there's a big cop conspiracy cover-up. It's usually ridiculous. This is one of those cases where it really seems to line up and it doesn't sound so unreasonable. Do you agree?
Well, no, I'm going to use your word. Again, I follow evidence. I don't follow conspiracy theories, and I don't follow what other people are saying, and I don't follow commentary. So I would say that the conspiracy theories that have been thrown into this thing, to use your word, are ridiculous. And what I think the problem the prosecution has is that, and what I've watched of the trial, the witnesses, and I'm talking about the police, I've watched some of their testimony, and look, I'll be frank, it's abysmal. It is not very good. And it is painting this picture that these guys are so complete in their incompetence.
Okay, so let's throw out all of this evidence, right? Let's just keep Karen Reed's own statements and the accident reconstructionist and the Cellbrite technology. I think you could throw out I think we all agree that it was John O'Keefe who was the victim in this case. I don't see how any of this, say this was done abysmally, is going to prove that anyone else did it. You have witness after witness testimony saying that John O'Keefe never made it in the house. John O'Keefe's own phone supports that. Karen Reed has said that at the key moment, she looked away. So she doesn't even know if he went into the house that night. But she's sure she knows who did it, which is also should make you raise an eyebrow. But I really wonder, I thought the cops came off well. And all this talk about they didn't put up crime tape, they put up crime tape. They didn't talk to the witnesses in the home, they sure did. Just he didn't want to talk to them because he knew them. So I haven't seen this abysmal. If this were more important, if this were some sort of like whodunit, maybe. But you have to prove that he went in the home that night, and you can't get him in the home. Even the defense can't put him in the home that night. So what are we talking about here? And because Ashley Banfield hasn't done her due diligence and doesn't care about it, she's not going to push back and say, well, how would a better investigation, how would any of these, how would it change anything?
That's a distraction for the prosecution. And the defense is jumping on that, and they're taking all of these facts, but they're not leading to the truth. And so, and
I keep coming back to the taillight. There's a photo of it, and it looks like it's intact when she leaves. And so I keep coming back to that to start me on the process of how could that. But that's for another day, Phil Water. Thank you for watching. Go to newsnationnow.com to find News Nation on your television provider.
So there they go. There's some balance, fair and balanced. both talking heads say, oh, it's terrible for the prosecution. All the witnesses have been terrible. The investigation was terrible. It's all terrible. Please hit the thumbs up if you guys are enjoying this episode, or hit the thumbs down if you're not. But it does certainly help the algorithm. All right, now this gets us into Vinnie Politan last night. Oh boy. He got everyone's favorite, Janine Driver, Mrs. Palms Up, Ms. Wendy Adelson is so truthful because her palms were up. Ms. I have zero background in behavioral lie spotting. I worked for the Bureau of Alcohol, Tobacco, and Firearms, and I gave lectures on the Brady Bill. I mean, how do these people have careers? When they're talk about ridiculous, but she chimes in here. Let's take a look.
Some testimony about him, the son of Julie and Chris. What time did he get home? Because the defense seemed like they were very focused on whatever time he came back to his home where Julie and Chris were.
So when we heard about that timeline of effects with him, it was through Julie's testimony. And what she was saying was both she and her husband got home at around midnight. And then she's claiming that 10 to 15 minutes after that, that's when their son walked through the door. And she says that she remembers that because she doesn't go to bed unless she knows where her kids are. And if they are home, then they're home with her. But, you know, she was also asked about any injuries that she possibly saw with him. She said that she didn't notice any injuries, and where he was that night, she says that he was at a friend's house.
Also, what's so shocking about these witnesses is just one after another, how John O'Keefe's spirit really comes through and what a lovely person he was. And to get these text messages back and forth from John O'Keefe, really bring him alive. And the way that they're told about what happened is so concerning from Karen. It hasn't been good for Karen. But like I said, I feel like we may have gone into a different area of law here where it's sort of mob rule. Sort of the outside mob has descended into the courtroom. And let's see if this is going to be the court of public opinion speaks or the actual trial done in the courthouse. Is the evidence going to be considered, or is it just going to be follow the mob? That's been so lied to by these really, really disturbing characters.
Okay. Significant testimony because I think where the defense wants to go with Colin Albert, trying to put him in the middle of everything happening at the house. But another big day today. Even it's a half day and it's a big day. It's really unbelievable how things are developing. Matt Johnson, Court TV Crime and Justice correspondent. Thanks so much, Matt.
Thank you.
I want to bring in a special guest tonight. Body language expert, author of the New York Times best-selling book, You Can't Lie to Me, and creator of the new free newsletter, In the Driver's Seat. Janine Driver is with us. Janine, thanks so much for joining us. I wanted to take a look at some testimony from Chris Albert regarding when his son came home, because I believe this will be a big, big issue for the defense if they try to somehow point the finger or implicate Chris's son, Colin, in being at the house when all this takes place. So let's take a look first at him testifying on direct examination.
Mr. Albert, as far as your son, Colin, do you know sort of where he was that night?
Yes, so he was at my brother Brian's house for my nephew's birthday.
And he came home sometime after you, is that correct?
Correct.
And essentially you came in, went to bed, so do you know what time your son came home that night?
I know that.
Do you know, just answer yes or no whether you know.
Yes,
And how do you know that, sir?
because he opened the bedroom door and said, "Good night, guys, I love you, I'm home."
And about how long after you got home was it that your son got home?
I'd say within 10 minutes.
All right, Gene, did you pick up anything there?
Oh, come on, Vinny. Did I pick up anything? Of course I did. You see, we see him take the tongue and stick it on the left side of his cheek. I want you to feel what that feels like.
I also picked up on that he may have some seasonal allergies and that he was doing a little sniffing like the rest of us middle-aged people. This is crazy. Should I get into her credentials one more time? They're not in body language. Her credentials are really on the Brady Bill, when the Brady Bill passed, giving lectures, but she has no background in this. She just is someone like very American, my opinion, made a career for herself out of whole cloth, and reinvented herself as a behavioral analyst, which is kind of an elastic term. So this is the kind of stuff we see in true crime. We see a lot of ex-FBI people, even if their background has nothing to do with investigating homicides, will come and weigh in and talk about all the cases they worked on or testified for. We see people who call themselves criminologists, another elastic term. Psychologists, psychiatrists come in as experts. Really take this with a big grain of salt. There is a reason why our legal system, we have 12 members of your peers come to verdicts and not 12 behavioral analysts or 12 ex-FBI or even 12 lawyers or psychologists. Our legal system is meant so that anybody can come to a reasonable conclusion after looking at the evidence. It's not so difficult that we need these experts to give us some kind of extra insight. So I think what she's saying is that here, Chris Albert was annoyed with Petty Yanetti's line of questioning, as anyone would be. But here's a great insight.
This is high stress has happened. High level pacifier in the face. The closer we get to the brain, the higher the stress. Listen, Indra Nooyi, former CEO.
You want to go through her credentials one more time? I did this when I was doing the Edelson case, excuse me. Hold on one second, guys. I'll pull it up. This is on her website. If I didn't get a chance to, I wasn't sure I was going to bring this up, but it is on Janine Driver. She luckily puts her CV up on her website so you can go through it. So we'll start all the way at the back here. Does everyone see it? So she went to Massachusetts College of Liberal Arts, where she studied English and communications. She says she has a GPA of 3.5. And okay. And her first job was at the Bureau of Alcohol, Tobacco, and Firearms as an industry operation field investigator or a trafficking inspector. Okay, so then she became a public information officer, provided information to media outlets. So she's media savvy. This is 1996 to 1999 in New York and Manhattan. She provided information to media outlets by generating news releases. So she was like their press person, holding press conferences and acting as a department spokesperson and media liaisons, okay? Then she was the program manager. She developed and led a focus training when the FBI, when the Brady Bill was enacted, to tell everybody what the Brady Bill was about. Then she was a field supervisor in Seattle, Washington. She was assigned to the Seattle Field Division of the Bureau, responsible for the prevention, detective, and investigation of substantious and conspiracy types violations. So basically, alcohol, tobacco, and firearm stuff. Then she managed a training program that is of major importance and primary to the Bureau missions on firearms and tactical defense tactics, according to hers. Okay, now we're getting more current. She was the training, that was the end. So from 2000 to 2008, she developed training programs for the analytic. She says this is on detecting deception, and I doubt that. And cognitive interviewing. I'm just going to be skeptical about those things that she added here to the front page, because it seems to come out of the blue. Developed and implemented new and ongoing programs. And then she started writing books on body language. And she's became a Body Language Institute. She became starting in 2003. She started this side hustle as a Body Language Institute. She's a New York Times bestselling author. So does that give you an idea? Hope so. As a senior, as Hey Manny says, as a seasoned behavioral criminologist and expert in the field of courtroom body language, I have to agree that it looked like guilt and very sus. Karen Reed, yeah. Right. It's pretty much anybody can make themselves a body language expert.
She was being interviewed.
Hold on one second. Hold on one second.
Just after Trump became president, she was chosen to be on his panel of executives. As soon as she comes out, Indra Nooyi did this. And you knew, I was watching it, I'm not political, I'm a political idiot. And I'm like, something's happening here. And then the first question was stress related. So we see it right there, you're looping it, your producers are doing a great job. So that high stress, it doesn't belong here. If in fact he was home at 12:15, why are you showing us high stress? Now maybe, let's play devil's advocate, Vinny, and you at home. Maybe it's like, well, because your son's being considered being part of.
Yeah, maybe it's because you're in a high profile criminal trial as a witness where you've been harassed for years on end. And now you're on TV where every part of your appearance, your life has been doxxed. Say you're not really jazzed. Maybe that wouldn't make you so jazzed to testify. Why is he so stressed out? Why isn't this just like a walk in the park for him to testify in front of a pitchforky mob ready to accuse you of the worst crimes at a drop of a hat? How disingenuous can you get, Janine Driver?
For murder. So then, therefore, the stress goes high.
Let's take a look now on cross-examination, which is always stressful for anyone on cross-examination. But let's take a look. This is a little longer part of the testimony.
With regard to the timing of how long it took you to go home, I believe your best estimate is about 5 minutes. Is that your testimony? And when I say home, I'm not talking about from D&E Pizza. I'm talking about that early morning when you're at the waterfall.
I understand. Yeah, I'd say around 5 minutes. I think from the waterfall to Maple Street.
Fair enough. So now, if you're leaving the bar at like close to 12:14, as indicated on the video, you're getting home somewhere around 12:19, 12:20, correct?
Roughly, yeah.
If you're getting home upstairs to your bedroom around 12:20 and it takes you 15 minutes to go to bed, and that's around 12:35, then sometime after you're asleep, after 12:35, that's when Colin opens the bedroom door, correct?
I don't remember exactly.
Well, it's difficult for you to remember how long you'd been asleep for when Colin opened the bedroom door, correct?
Correct.
You don't know if it was 5 minutes, 10 minutes, or longer, correct?
I don't know exactly.
Right. But it was some time after you fell asleep.
To the best of my recollection.
Okay, Gene, what's going on there?
Whole bunch of stuff, Vinny. We see some contempt happening here, which is a smirk. It's the only unilateral expression on one side of her face, and he goes like this. We saw A-Rod do this when he was lying about taking steroids with Katie Couric back in the day. So moral superiority, it doesn't belong here.
Yeah. Oh, doesn't really? Because I was probably making that same expression listening to Betty and Eddie and that ridiculous cross-examination. Moral superiority doesn't belong here. Yeah, I think it does. I think it does, Janine. You have a really sleazy defense team, in my opinion.
Moral superiority is often done by a powerful person who's getting away with deception. And what else does he do? He touches his face. And you see a nose wrinkle a little bit? We saw this with Kate O'Callaghan. When Kate O'Callaghan was on the stand with the O.J. Simpson case, and Marsha Clark said, isn't it true?
Yeah, we see this with O.J. Simpson. Perhaps he had a seasonal allergy itch. He's been sniffing the entire time up there. I'm convinced he has seasonal allergies. Oh, this is so ridiculous. And he touched his face. His nose might have been a little itchy. Pollen is at an all-time high. But here he feels morally superior. Who couldn't feel morally superior to David Yannetti after the things he's pulled in this trial? You would have to be totally lost your moral compass years ago to not feel morally superior.
You're writing a book or getting this deal, and he's like this. And so that's what we're seeing right here, which is disgust. It's like, I don't like these questions. High stress, I don't like the questions, and moral superiority, not a good combination for the truth.
Janine Driver, thanks for helping us out. We're going to be calling you a lot more during the course of this trial. Many more witnesses.
Yeah, I'm a Boston girl, I'm from Massachusetts.
There you go.
I appreciate you having me on, Vinny. Thank you.
So you can understand the accent much clearer than sometimes I can. All right. Folks, we got a lot more to get to. We're going to talk about the next morning at Brian Albert's home after John O'Keefe has been taken away. Who is there? Why are they there? We'll bring in our guest. Plus, coming up next hour.
Where is Harmony Montgomery? This 5-year-old angel disappeared in 2019, but no one
went there that morning.
I opened my car door. I got out to walk to the car in front of me to leave the donuts and card inside my nephew Brian's car. And Brian Albert came to the door. Brian Albert Sr. came to the door, and he told me to come in, asked me to come in for a second. And I said that I didn't need to. And he said, I'm just leaving this gift for Brian Jr. And he said, no, just come in for a second. So I went into the house.
And when you walk into 34 Fairview Road on that morning, if anyone else was there?
Nicole Albert, Brian Albert, Brian Higgins, Jennifer McCabe, and Matt McCabe.
And where were they in relation to the house?
In the kitchen.
And what, if anything, did they tell you at that time?
When I first walked in, nothing. Everyone was just sitting there, and I was looking around, and everyone was visibly upset. And I asked, what's going on? And another maybe 30 seconds went by, and Jen said, something's happened to John. And I said, John, she said, John O'Keefe. And I said, is he okay?
Objection.
No, I'm going to allow it.
I said, is he okay? And she said, we don't know. And that was that.
Let me bring in my guests. Joining me, Karen Reed supporter and expert Nick Rocco, criminal defense attorney Joseph Krowski Jr., and the YouTuber behind Yellow Cottage Tales, Kevin Lenahan. Great to see everyone tonight. Nick, let me ask you first, from your perspective, the donuts in the morning, everyone is there. That's when she finds out. What do you find significant about all of this?
Well, first off, you have all the witnesses that were somewhat involved in this, all congregating inside 34 Fairview Road, where nobody really knows what was said. But as far as the outcome of it, Jennifer McCabe ended up having Lieutenant Lank come back to the house.
It was actually a secret donut ritual that they all took part in. They passed the donuts around. It's a little bit like the mob ritual when you become a made man. But there's only one Boston cream donut, and they pass it around blindfolded, and whoever gets the Boston cream donut becomes the head of the conspiracy. So that's how they all decided that they were all gonna be quiet, don't say anything. It's the donuts sealed everyone's fate. Everyone was in, we're all a group now. We're the team donut, right? And it's not a coincidence that cops and donuts, there's a connection, right? This guy needs his head examined.
And that's when she said, oh, hey, come back to the house. I forgot to tell you something. So when he comes inside the house, she says, I forgot to tell you. I heard Karen say, I hit him, I hit him, I hit him. So if you don't think that those people inside that house were coming up with a plan, then I would disagree with that, because at this moment, when they're all inside that house, Jennifer McCabe is now aware that Karen Reed's taillight is broken, because when Jennifer McCabe...
They wrote the script in donut icing. Then they somehow figured out who all the first responders were, and they got their story. It wasn't that Karen Reed told every single person there that day that she did it, that she hit John. It's that they all met inside after everyone was gone. John was at the hospital, and they all decided, right, to get a story somehow to the first responders, that they all knew who they were, right? They all had ways to get this to them. And they wrote the script out in sprinkles and donut icing. That's the way it went down. Then they ate it because they didn't want to leave. They didn't want to leave proof. It was this is a very sophisticated operation that was done. It was the pastry wall of silence. And that's almost impossible to get past.
Even Kerry Roberts picked Karen up at John's house. Karen saw, that was the first time she saw her taillight was broken, and she pointed it out to Jen and Kerry. So at that point, Jen knew it was broken, and when she went back to Brian Albert's house, I'm sure she told Brian Albert, hey, Karen's taillight was broken, and the plan began right there. So there was a reason why Lieutenant Lane came back to the house.
So this is significant for the defense. Kevin Lenahan, do you see anything unusual or nefarious about what's going on the morning after as Julie's bringing the traditional 6 Dunkin' Donuts for her nephew for his birthday?
I think what it's important for people to do in any case, but certainly here, is try to look at these things from a both sides kind of way until you get all the evidence in. So you look at something like this. Is it possible that these are the master conspirators getting this story together? Okay, that's option A. But option B, does that make sense too? that Brian Higgins, who was, for instance, friends with John and had been partying with these guys, is it normal that he would be there the next day to find out what happened? Yes, it's normal. So both of those things have kind of equal weight until you look at the other evidence in the case. I think it's important not to try to fit everything into a conspiracy theory or another kind of theory that you've already bought into ahead of time. That makes sense.
Joseph, two things. One, I want your response to the gathering of the people, but
sure.
What also is significant to me, this is only like 8:30, and we've cleared the crime scene already?
Right. So let me deal with them in order. I think I saw Nick's tongue pushing his right cheek out. I don't know if he's nervous or lying. Look, if there's some sort of conspiracy to cover up a crime, they would have done it that night. They would have done it supposedly when they were going through these extravagant efforts to cover up the crime scene outside and construct what appeared to be a crime scene outside, and cover up one from inside. This is a normal reaction. They had just been out with that man. They had, by all accounts, been getting along with that man the night before. To find out that something happened and he was injured and later deceased out in the front lawn, I think it's a normal reaction to get together like that. Sure, the crime scene, I mentioned that last night. You would have expected, and again, this goes more to the negligence of the investigation. You would have expected that that crime scene would have been frozen pending a search warrant, and that the local police, in conjunction with the state police, would have done a much more robust grid and search and investigation of that crime scene. But that has nothing to do with some sort of purported cover-up. You know, every single detail that comes out, the other side seems to just have conjecture and speculation. There's no witnesses. If we would get some time, I'd love to go back to Chris Albert's testimony in the great anticlimactic thud of the so-called motive evidence against Colin Albert.
Oh, we'll get there. You're getting ready.
Oh, we'll get there. Don't say it's all total BS. Don't actually call us out on totally bringing. This is getting a little wacky. I'm going to just try to remove it and add it.
Producing tonight. Last night we brought on a director, Kevin.
Right. Don't try to get totally rational here and say the defense actually doesn't have anything. We got a free Karen reader willing to kind of make it look like there's some sort of conspiracy, but don't get too detailed about it. Just kind of wave the idea over the whole trial. And then you have a lawyer talking sense like, what? The defense has nothing. The defense has nothing. No, we'll get to it. We'll get to it. We'll fully explore that nonsensical defense talking point.
Tonight you're producing, which is great. So we'll get to that in the next segment. Let me play some more of Julie Albert's testimony. This time talking about what connection that she has to the Proctor family.
Prior to February 10th, no investigator from this case bothered to talk to you or your husband, correct?
Correct.
Now, in terms of the two investigators who did come, you knew one of them quite well, did you not?
I knew them. I wouldn't say quite well, but I knew them.
Okay, and when you say you knew them?
Him. I'm sorry, him.
Okay. And who was it that you knew?
Michael Proctor.
Michael Proctor was the brother of one of your close friends, correct?
Correct.
You're close friends with Courtney Proctor, correct?
I am.
Okay, Nick, how much of an issue is this, do you believe? The fact that Julie Albert's good friends with...
Hey, Manny asks, Karen Reed, what evidence do you think will rock the defense and Turtle? What will cause them to backtrack? Well, I don't think they'll ever backtrack because it doesn't matter how many people, it doesn't matter that they don't have a cohesive defense talking point. They've moved it, just like the West Memphis 3, they moved it from talking point from Brian Albert did it, to Brian Higgins did it, to Colin Albert did it, to they're all, every witness is lying in this case. I think the forensics, and then you can't trust any of the forensics, right? So every part of this investigation is bad for the defense. All the people are lying, every single one of them. It's all a giant conspiracy, but they can't say exactly how. How these people, did they get out in a hot air balloon and not leave any prints or any, they're all lying in that nobody saw Brian Albert come in. The phone data is lying, where Brian Albert's phone data under his body showed that he didn't move. I think it's going to be the totality of it if they can keep this campaign out of the courtroom, which I'm not convinced they can. We make it a very wacky verdict. I'm not convinced that the judge has secured her courtroom. I think it's very scary when this happens. And nobody wants their family to be harassed. Nobody wants to be doxxed. And that's the implication when you have someone like Aidan Kearney, who's going to go on trial for witness intimidation, walking around the courtroom, taking a good look at the jurors who are supposed to be protected. So I don't know. There's the microscopic pieces of taillight in John O'Keefe's shirt is very damning for Karen Reed. The hair from John O'Keefe on her bumper, they're going to say he just slept with his head on her bumper because it was more comfortable than a pillow, and it's just regular transfer. I think Jen McCabe, Carrie Roberts could be very damning. They're going to try to destroy both of those witnesses, could be very damning. But very seldom does a jury say, I can't trust this investigation, therefore I'm going to kind of nullify it. Doesn't matter if she did it or not, especially on a murder case. So I can't see. Yeah, it's all very damning. A lot of stuff's going to come out. Certainly, I would think the testimony of John O'Keefe's adoptive kids, his niece and nephew, is going to be very damning to Karen Reed. But show me the motivation to lie. And all these witnesses have been so believable and so likable.
The lead investigator, Trooper Proctor's sister.
Well, I think we've known this for a long time. It's just that finally Michael Proctor admitted to having these relationships due to the federal grand jury. But one thing that I find very interesting is in Julie Albert's police report to Michael Proctor, she stated that she was sleeping at 4:55 when she had been awoken by a missed call from Jen McCabe, and that is how she found out that John was dying. So she found out at 4:55 in the morning John was dying, but they didn't find him until 6:09. And Kevin, that's in her interview with Michael Proctor. You can read it. It's there. I know she changed her testimony today. It's there. Read it.
Go ahead, Kevin.
I've read it. I'm not going to go over that, but I want to bring up something that I'm glad Nick did bring up, which is the federal aspect of this here. Now, you may have noticed today that Yannetti pointed out to Julie that she had 67 calls in that 6-month period with Courtney Proctor. Now, I think that's actually pretty normal since this case affects both of them, or maybe they're just conspiring, right? But where did that information come from? The feds. Okay, that if the feds got 6 months worth of data on Julie and Courtney, that means they also got it on everybody else: Colin, Brian Albert, Chris Albert, everybody involved here. And yet they found no evidence of a cover-up. No one is a target. No one is charged or anything. That federal investigation is inculpatory to Karen Reed.
Joseph, your thoughts about
So for those in the back, that's the FBI report. So the FBI agrees. For those in the back, FBI agrees with the Commonwealth as to manner of John O'Keefe's demise. It's going to be very bad for the free Karen readers. But just know that this is a kind of mindset. They don't respect the court. They don't respect the process. And that's why they don't mind the process being corrupted like this. Karen Reed didn't even want to clear her name. She didn't even want to go to trial with all the money she's raised to clear her name and show everyone all the great evidence of her innocence. That should raise an eyebrow. Scary. This is such a scary case. Because if this works, if this gets Karen Reed off, this campaign, this is going to be the future. So it's going to be, how much money do you have for a disinformation campaign? How aggressive a blogger can you get? Who can you hire? How can you pervert our media into steering away from any of the really important evidence in the case? And representing this case like it's all about red paper, red plastic cups, when it doesn't, it's not the important evidence. And just skip over that every single, practically first responder, except one, heard Karen Reed take ownership of this crime. I did it. Not could I. And even if she said, could I have done it? She's putting it in the realm of possibilities that it is probable that she could have done this. Possible and probable that she could have done this. So I don't find her saying, well, it was preceded by a did, right? Preceded by a did and proceeded by a question mark. Did I hit him? I don't find that all that exonerating, Karen. You're saying you could have done it. It's possible. You're capable of this.
This connection, is it troublesome? Is it a problem? Proctor?
So do you guys have questions? Do you have questions? Just use a red emoji, and I'm going to kind of wind down here at the end of this. I mean, to call this free Karen Reed basically puppet, an expert on anything, is ridiculous, but okay.
His sister, the Alberts, they know each other. He's the lead investigator here.
Well, certainly as a defense attorney, you love it, you embrace it, right? It is a problem because John O'Keefe deserved an investigation free from the appearance of impropriety. John O'Keefe deserved an investigation unfettered by any potential conflict of interest. And Karen Reed, a presumed innocent defendant, certainly deserved and has a constitutional right to an investigation without a conflicted chief investigator. So certainly it is a problem. Now, it's a leap to go from there to have the same trooper driving all over Canton, planting pieces of tail light and planting hairs from John O'Keefe's head. But certainly, yeah, it's a problem. It should have been disclosed, and he should have recused himself early on. Had he done that, the investigation and the prosecution is a lot cleaner. Had he done that, someone like Colin Albert, who's become collateral damage in this case, who's become a victim, there's no...
Right. They created so many victims in this case. Murder by Maestro asks if you have a question. Oh, put it. Thank you. That's you, Murder by Maestro. Yeah, just use the red emoji. So it's really hard for me to see if you ask a question without a red emoji. Hard for me. Thoughts on the judge? Well, my understanding is she's a very defense-friendly judge. And I know the free Karen readers are getting upset because when the defense tries to crowbar in questions that basically third-party questions that they've been forbidden to argue, that she sustains the Commonwealth's objection. So yeah, if you're going to ask a lot of, I think she's been pretty fair, but I think this was a terrible decision today. I don't think she really understands how dangerous, or I hope she didn't make this decision understanding how dangerous this Free Karen Reed campaign is. I think her decision to put protesters 200 feet was too close to the courthouse. And I think that this was a terrible decision to let Aidan Kearney into the courtroom at all. Whoever gave him a press pass, obviously Bradel his lawyer admitted that he helped him out and basically strong-armed the office into giving him a press pass. But the judge should have seen him and said, you're out of here. And I know there were a lot of complaints and complaints attaching video of Aidan Kearney talking about how mission was done to poison the jury pool and don't get caught if you're a juror. And don't get caught lying. Basically, get on the jury and nullify this case. Get it done, no matter how. Any means possible kind of thing. So she's protecting the kids. I mean, I'd be curious to see if any of the press objects and says, we have a First Amendment right to report on the kids' testimony. But they put out a full media blackout, so we'll never know until, I guess, after the verdict, and we can get the court transcripts, what John O'Keefe's adopted kids, his nieces and nephews, I don't know if he officially fostered them or adopted them, but he took care of them for years and years, what they said about the relationship with Karen Reed. And I think it's hurtful to Karen Reed to have all these people say we liked her. So again, there goes the defense's theory. Oh, we liked her so much that we all wanted to pin this crime on her for nothing? They're not getting it. Lovely Sphinx says, I completely agree with you. Biggest media corruption. Hope the jury can see through this BS. It's getting scary, Lovely Sphinx. You need to take colloidal silver. I am on a massive dose of antibiotics. But thank you, Lovely Sphinx. I have used colloidal silver before. Thank you. Let's see. Hey Manny says, with all due respect and jokes aside, to your frequent point, Roberta, there's a lot of innocence fraud examples of criminals going free because of these tactics. It's already a phenomenon. Yeah, but we haven't seen it in real time. Usually those innocence fraud campaigns are after a conviction, not before. So this is a whole nother thing. Before a trial and during a trial and full out getting into harassing witnesses. It's scary. Super scary to me. Because once our justice system goes, society, that's the thing that holds together our society.
No oxygen fed to that. I see Nick nodding his head, but we'll get to Colin Albert. I mean, there's the fact that 2 years later, not a single witness puts Colin Albert and John O'Keefe within even close proximity to one another that night, but yet people still go on and on and on in putting forward this nonsensical, derogatory insinuation that he had something to do with the death of John O'Keefe is just beyond the pale to me.
Okay, everyone stay where they are. Nick Rocco, Joseph Krause Jr., Kevin Lanahan. We're going to talk next about the so-called lawn feud. Was this a motive?
Oh, Nebercracker. All right. I think we've done it, guys. I think we've done it for today. They're going to get into the Nebercracker defense, and I think we've covered that. The get off my lawn defense. Please hit the thumbs up, subscribe to the channel, leave me a 5-star review on Apple Podcasts. I'll be back tomorrow at 6 p.m. Eastern. Have a great night, everybody.